Committee of Creditors is a committee typically consisting of financial creditors of the corporate debtor. It is a supreme decision-making body in a CIRP. Decisions regarding the administration of the corporate debtor are taken at the meetings of committee based on the requisite vote of the members. It is responsible for giving approval to IRP or RP to carry out actions that might affect the CIRP. And in Committee of Creditors of SR Steel, Supreme Court held that the COC is a supreme and adjudicating authority cannot challenge the COC's commercial judgment. Section 21 and 24 of IBC Code makes provision relating to Committee of Creditors. Section 21 deals with the constitution of the COC, while Section 24 prescribes the modalities for the meetings of the COC. Section 28 of the code lists out certain actions that may be taken by the RP only with the prior approval of COC by a vote of 66% of the voting shares. The code made IBBI IBBI has made the IBBI Regulation 2016 in exercise of the powers conferred under Section 579, 14, 15, 17, 18, 21, 24, 25, 29, 30, 196 and 208 read with 240 of IBC Code. These regulations make detailed provisions for effectively regulating the IRP for corporate persons, that is CIRP, and amended time to time by IBBI. Regulatory provisions for relating to COC. So, Section 21, 24, 25A, 28, 21, 24, 25A, 28. These are all related to COC. And certain provisions under the board IBBI. First, 21 is about COC. The IRP shall, after collation of all the claims received against the corporate debtor and determination of the financial position of the corporate debtor, constitute a COC. The COC shall comprise all the financial creditors of the corporate debtor, provided that FC or authorized representative of FC referred, if it is a related party of corporate debtor, shall not have any right or representation or participation or voting in a meeting of the COC. So, if related, nothing he will be having in COC. Provided further, the first provision shall not apply to the FC regulated by the financial service sector regulator if it is related to the corporate debtor solely on account of the conversion of a substitution of a debt into equity or equity shares or instruments convertible into equity, or completion of the such transaction as may be prescribed prior to insolvency commencement date. So, financial sector regulator, in that they have given the exception, even if FC is related party, he can be counted in the quorum and have the all rights and participation if before the ICD he became the related due to conversion of a debt to equity or any other instruments. Subject to subsection 6 and 6A, where the corporate debtor owes financial debt to two or more financial creditors as a part of the consortium or agreement, each such financial creditor shall be part of the COC and their voting shall be determined on the basis of financial debts owed to it. Where any person is a FC as well as OC, so FC and OC, then what happens? Such person shall be a FC to the extent of financial debt owed by the corporate debtor and shall be included in the COC with the voting share proportionate to the extent of financial debt owed to such creditor. So, till the portion of financial debt only. Next, such person shall be considered as OC to the extent of operational debt owed to the corporate debtor to such creditor. So, separately they will be counted. Where an operational creditor has assigned or legally transferred any operational debt to a FC, the assignee or transfer shall be considered as OC to the extent of the such assignment. Where the terms of the financial debt extended as part of the consortium arrangement or syndicated facility provide for a single trustee or agent. So, consortium has been provided for the single trustee or agent to act for all the FCs. Such FC may authorize the trustee or agent to act on his behalf in the COC to extent of his voting share, represent himself in the COC to extent of his voting share, appoint an insolvency professional other than the RP at his own cost to represent himself in the COC to the extent of his voting share, exercise his right to vote to the extent of his voting share with one or more FCs jointly or severally. Where a financial debt is in the form of securities or deposits and the terms of financial debt provide for appointment of a trustee or agent to act as a AR of all the financial creditors. Such trustee or agent shall act on behalf of all the financial creditors. Is owed to a class of creditors exceeding the number as may be specified other than the creditors covered in clause A, the IRP shall make an application to the adjudicating authority along with the list of all the financial creditors containing the name of the insolvency professional other than the IRP to act as an authorized representative who shall be appointed by the AA prior to the first meeting of committee. Is represented by a guardian, executor or administrator. Such person shall act as authorized representative on behalf of such financial creditor. So financial creditor is being represented by his guardian, executor or administrator. Shall attend the meetings of the COC and vote on behalf of each financial creditors. The remuneration payable to AR shall be as per the terms of financial debt or relevant documentation, and fees shall form part of the CIRP cost. The board may specify the manner of voting and determining the voting share in respect of financial debt, save as otherwise. All decisions of the COC shall be taken by a vote of not less than 51%, not less than 51, not less than 51% of voting share of financial creditors, provided that where a corporate debtor does not have any FCs, the COC shall be constituted and shall comprise of such person to exercise such functions in such manner as may be prescribed. The COC shall have the right to require the RP to furnish any financial information related to corporate debtor at any time during the CIRP. The RP shall make available any financial info so required by the COC within a period of 7 days of such requisition. So the below box constitution of committee, first section 18 they have given. So this can be used as intro to the duties of IRP, and section 21 this also can be intro. For section 21, instead of writing directly section 21, we can use this as intro. Next, definition of claim they have given, and composition of COC. Composition of COC, all COC shall form by financial creditors only, and financial creditor meaning they have given, and can home buyers be considered as FC? Yes. In the given case it has been declared FC. Even home buyers, that is real estate allottees, is also FC. Exclusion of related party, proviso to section 21(2) provides that FC or authorized representative of the FC, if it is related party of corporate debtor, shall not have any right of representation, participation or voting in a meeting of the COC. So related party means they have no right to be in the COC and to participate and to vote, nothing they have. Subsection 21(1) of the code provide that IRP, after collation of all the claims received against the corporate debtor and determination of financial position of the corporate debtor, shall constitute a COC. This can be used as an intro to COC. Committee of creditors to consist of FC. So here again repeated only, if FC is related, they cannot have any right or nothing, they can and they cannot participate vote in COC. And if that is owed to more than 1 or 2 FCs, that is consortium or agreement, they will sit according to their portion in the COC. And if financial sector regulator, then even if they are a related party, because of conversion or substitution, they can be sit in the COC and they have the all participating and voting rights. When creditor is FC as well as OC of the operational corporate debtor. So these are also related. Such person shall be FC to the extent of FC and can sit in the COC and can vote also. And if such person is considered as OC, will be considered as OC to the extent of the operational debt owed to him by the corporate debtor, and where operational debt creditor has assigned or legally transferred to a debt to financial creditor. So financial creditor will sit in the COC till his part, and OC to the extent, and both will be dealt separately. And next, related party definition. And in case of Phonex ARC private, related party definition once more clearly described. And in next page there is a box insolvency process cost, what and all will come under insolvency process cost. And in next page there is a financial sector regulator, meaning the COC is composed of FC of the corporate debtor, as the FC have the capability to access the commercial viability of the corporate debtor and are willing to modify the terms of the debt contract in negotiations between the creditors and the corporate debtor. OC on the other hand are not equipped to decide on the matters relating to commercial viability of the corporate debtor, nor they are generally willing to take the risk of restructuring their debts in order to ensure the management of the operation of a corporate debtor as a going concern. This both para can use COC consists of FC only. Why? This can write. And next, voting share, meaning they have given, and assignment or legal transfer of the OC. Financial debt, 2 or more FC as a part of consortium, so they will act according to their financial debt owned. A single trustee or agent to act for all the financial creditors. Where the terms of the financial debt extends as a part of consortium arrangement or syndicated facility, provide for single trustee or agent to act for all the financial creditors. Each financial creditor may authorize the trustee represent himself, appoint the IR insolvency professional at his own cost, and exercise his right to vote to the extent of his voting share. And amendment to provide for a mechanism to allow participation of security holders, deposit holders, and all other classes of financial creditors which exceed a certain number in meeting of COC through an authorized representative. Means through authorized representative, even they can also form part of COC. A trustee or agent to act as AR shall act on behalf of all such financial creditors. Financial debt owed to a class of creditors exceeding the specified number. Other than discussed above, other class of creditors, even they want the authorized representative, then insolvency IRP will make a recommendation to adjudicating authority. He will make an application that AR is required, and he will recommend the in insolvency resolution professional also, other than the one who is presently taking care of ICIRP. And financial debt is owed to a class of creditors, means here 10 numbers, 10. If 10 people are there, financial debt means example debentures. If 10 people are there in the debentures, then for 10 people one can be AR. Operating separate bank account for each real estate project. Where the corporate debtor has any real estate project, the IRP or RP, as the case may be, shall operate a separate bank account for each real estate project. And here gave financial information definition. Financial debt is represented by a GE or A, then such person shall act as a AR on behalf of the FC. All such AR shall attend the meetings of the COC and vote on behalf of the each financial creditor to the extent of his voting share. Board to specify the manner of voting and determining the voting share. The board may specify the manner and voting, determining the voting in respect of financial debt covered. And remuneration payable to AR. It provides that remuneration payable to AR shall be as per the terms of financial debt or relevant documentation, and shall be specified which shall be form part of the insolvency resolution, so it will form CRP cost. Decision of COC. Court provides that except as otherwise provided, all decision of COC shall be taken by vote not less than 51% of the voting share of FC. If there is no FC for a corporate debtor, the COC shall be constituted consisting such persons and exercise such function in manner as prescribed. Financial information. The COC shall have the right to require the RB to furnish the financial information in relation to corporate debtor at any time during the CRP, and he should make it available within 7 days. Submission of proof of claims. Regulation 12 of IBBI regulations provide that a creditor shall submit a claim with the proof on or before the last date mentioned in the public announcement. The creditor shall submit claim with the proof on or before last date mentioned in the public announcement. If he failed, he can submit with the RP or IRP up to 90 days from the insolvency commencement date, or up to the date of issue of request for resolution plan. So before requesting requesting up to then allowed, whichever is later. Provided further that the creditor shall provide reason for the delay in submitting the claim beyond the period of 90 days from the ICD. Such inclusion shall not affect the validity of the decision taken by the COC prior to such inclusion. And verification of claims, Regulation 13, the IRP shall verify every claim within 7 days from the last date of receipt of the claims, and thereupon maintain a list of the creditors with the amount claimed by them and the amount of their claims admitted and the security interest, if any. Where the IRP or RP, as the case may be, does not collate the claim after verification, he shall provide the reasons for the same. And in the event if the claims are received after the period, he shall verify all such claims and categorize them as acceptable or not acceptable for the collation. Collation means calculate or collecting. And IRP or RP shall intimate the creditor within 7 days of categorization thereof, means acceptable or not acceptable. After this category, the IRP or RP has to intimate to creditor, respective creditor, within 7 days. Put up the claims categorized as acceptable and collated by him to the committee in the next meeting for its recommendation for inclusion in the list of the creditors and its statement in the resolution plan. Submit such claims before the AA for condonation of delay and adjudication wherever possible. The list of the creditors shall be available for inspection by the person who submitted proof of claim, available for the inspection by the members, partners, directors, guarantors of the corporate debtor and or authorized representative, displayed on the website if any of the corporate debtor, filed on the electronic platform of the board for dissemination on its website, provided that this clause shall apply to every corporate CIRP and ongoing and commencing on or after the date of IBBA regulations came into force. Filed with the AA and presented at the first meeting of the committee with only operational creditors. Regulation 16 deals with situation where either the corporate debtor has no financial debt or where all the financial creditors are related parties of the corporate debtor. So, where the corporate debtor has no FD or no FC or all the FCs are related, the committee formed under shall consist of members as in the first 18 largest operational creditors by value, provided if number of operational creditors is less than 18. The committee shall include all operational creditors. One representative elected by workmen and one representative elected by all the employees. Total 20 should be, one representative by employees, one representative by workmen, and 18. Total 20. If less than 18 members are there, so all will be forming part. If more than 18 means, we will categorize depending on their largest operational credit. The committee formed under this regulation and its members shall have the same rights, powers, duties, obligations as a committee consisting of FC and its members as the case may be. Regulation 16B. Section 16B deals with the situation where the corporate debtor has only creditors in a class and no FC is eligible to join the committee. Where the corporate debtor has only creditor in a class and no other FC eligible to join the committee shall consist only of authorized representative. Regulation 16A of IBBI, the IRP shall select the IP who is the choice of the highest number of FCs in the class in Form CA received to act as an AR of the creditors to the respective class. Next, the IRP shall apply to the adjudicating authority for appointment of AR selected within 2 days of the verification of the claim received, and if any delay in the appointment of AR for any class of creditors shall not affect the validity of any decision taken by the committee. Financial creditors in a class representing not less than 10% voting share may seek replacement of AR with an IP of their choice by making a request to IRP or RP, who shall circulate such request to the creditors in that class and announce a voting window open for at least 24 hours, subject to the IRP or RP shall offer choice of at least 3 IP to the financial creditors in class, including such IP proposed along with the existing AR. The RP shall apply to adjudicating authority for appointment of AR who receives the highest percentage of voting share in the financial creditors in that class. The IRP shall provide the list of each class to respective AR appointed by the AA, and IRP shall give updated list of creditors also to AR, and IRP or RP shall provide a electronic means to communication between AR and creditors in the class, and the voting share shall be in proportion to the financial debt, which includes an interest also at the rate of 8% per annum unless a different rate has been agreed between the parties. The heir of creditors in class shall have eligible for the fee if number of creditors in a class is 10, 10, 10 to 100. A for 1. So starts from 10, 1, 1, 10. So 10 to 100, 10 to 100. For 10 to 100, 30,000, and 101 to 1,000, 40, and more than 10, 1,000, 50,000. The payment of fee to AR shall be part of the cost, that is CRP cost, in respect of 2 meetings with the creditors he represent corresponding to a meeting of the committee. See, if one committee of creditors meeting for 2 creditors, class of creditors meeting is allowed. The fee for any additional meeting beyond 2 corresponding to a meeting of the COC shall be part of the cost subject to approval of COC. AR shall circulate the agenda to creditors in class and may seek their preliminary views on any item in the agenda to be enable him to effectively participate in the meeting of committee, provided that creditors shall have a time window of at least 12 hours to submit their preliminary views, and the said window opens at least 24 hours after the AR seeks preliminary reviews. So for preliminary review 12 hours, after preliminary review 24 hours window will be open for voting. Further, such preliminary review shall not be considered as voting instruction by the creditors. The authorized representative of financial creditors shall assist, review, help, assist the creditor in class he represents in understanding the discussions and considerations of the committee meetings and facilitate the informed decision making, review the contents of the minutes prepared by the RP and provides his comments to the RP, help the creditors in a class he represents during consultation made by the RP to prepare a strategy for making marketing of the assets of the corporate debtor in terms of work in the collaboration with creditors in a class he represents to enhance the marketability of assets of the corporate debtor, assist the creditors in class he represents in evaluating the resolution plan submitted by resolution applicants, have access to any information or documents required to form an opinion on issues discussed in the committee meetings on the progress of the CIRP, make suggestions for modifications of the resolution plan as may be required by the creditors in class, record proceedings and prepare the minutes of the meeting with creditors in a class, act as a representative for the creditors in a class he represents in a representation before the ANCLT and other regulatory authority. The provision regarding minutes of the meeting in this regulation shall apply same for sub-regulation 10. The creditors in a class may propose any additional responsibility upon the AR in relation to representation of their interest in the committee. In box, they gave the power under section 27 assumes significance particularly in a CIRP initiated by the corporate debtor. Where a corporate debtor has appointed a RP of its choice, the COC has the right to replace such RP if they suspect collision between the RP and corporate debtor or management. Next, section 24, meeting of committee of creditors. Prescribe the following modalities for the meeting of creditors, committee of creditors. The members may meet in person or by such other electronic means as may be specified. All meetings of the COC shall be conducted by the RP. The RP shall give notice of each meeting of the COC to members of COC including AR and members of suspended board of directors or partners and OC or their representative if the amount they are aggregating due is not less than 10% of the debt. And fourth, the director, partner, one representative of OC as referred may attend the meeting of committee of creditors but shall not have any right to vote. So director, partner, representative of OC will not have the right to vote, just they can attend the meeting. The absence of such director, partner, representative of OC as the case may be shall not invalidate the proceedings of such meeting. Okay. Any creditor who is a member of a committee of creditors may appoint an IP other than RP to represent such creditor in a meeting of the committee of creditors, provided fee shall be borne by the individual who has appointed. Each creditor shall vote in accordance with the voting share assigned to him based on the financial debt owed to such creditor. The RP shall determine the voting share to be assigned to each creditor in the manner, and the meeting of COC shall be conducted in such manner as may be specified. Regulation 18 states RP shall convene a meeting of committee before lapses of 30 days from the last meeting, means gap between two meetings is 30 days, provided that committee may decide to extend the interval between such meetings subject to condition that the threshold there shall be at least one meeting in each quarter. A RP may convene meeting if he consider it is necessary or on a request received from the members of the committee, and shall convene a meeting if the same is made by the members of the committee representing at least 33% of the voting rights. It is clarified that the meeting may be convened under the regulation till resolution plan is approved and which do not affect the resolution plan submitted before the AA. RP may place a proposal received from members of the committee in a meeting if he considers it necessary, and shall place the proposal if the same is made by the members of the committee representing at least 33% of the vote. Quorum at the meeting of COC. A meeting of COC shall be having a quorum if the members of committee representing at least 33% of the voting rights are present either in person or by video conferencing, provided that the committee may modify the percentage of voting rights required for quorum in respect of any future meetings. Where a meeting of the committee could not be held for want of quorum unless the committee has previously decided otherwise, the meeting shall automatically stand adjourned at the same time and same place on the next day. In the event of meeting of the committee is adjourned in accordance, the adjourned meeting shall be quorate with the members of a committee attending the meeting, means how many people will attend, that much is the quorum. Regulation 20 service of notice by electronic means. This notice will be served to members of COC, suspended board and OC if representative if their debt is more than 10% of the debt. The notice may be circulated electronically by sending it to the participants via email as a text message or as an attachment or as a notification that includes electronic link or uniform resource located for viewing the notice. The name of a corporate debtor, location if any, and the time date of the meeting must all be stated in subject line of the emails. If notice is sent as a non-editable email attachment, it must be portable document format or another non-editable format and include a link or instruction for the recipient to obtain the appropriate software version. The RP must use a system that generates confirmation of the total number of email recipients as well as record of each recipient to whom the notice has been sent and a copy of such record. Any notice of any failed transmission and subsequent resending shall be retained as a proof sending when notice or notifications of availability of notice are sent via email. The duty of RP is fulfilled when he sends the email and he is not liable for the transmission error that are beyond or his control. So when he sent, then only his duty is fulfilled. Because of any transmission error that are beyond his control, he is not held liable. The notice circulated through the electronic link or uniform resource locator must be legible and the recipient must be able to obtain and keep copies of the notice. The RP must also provide the full uniform resource locator website address and instructions on how to access the document and or information. The failure of participant other than a member of the committee to supply or update the appropriate email address to the resolution professional will prevent that participant from receiving notice of any meeting but will not render the decision made at those invalid. Next, notice of meeting of COC. Time period for the notice 5 days, not less than 5 days, and can issue not less than 24 hours if there is no creditor in class. If there is a creditor in class, 48 hours is the maximum time within which should before the meeting commence 48 hours should give the notice. And contents. The notice of the meeting shall contain the following: a list of the matters to be disclosed at meeting, the list of the issues to be voted upon, copies of all docs. The notice of meeting shall state the process and manner of voting by electronic means, and this time schedules. Provide the login ID and details of the facility for generating password and keeping security and casting of vote. Provide contact details of the person who will address the queries. Regulation 23. The notice convening the meeting of the committee shall provide the participant an option to attend meeting through video conferencing or other audio and visual means. Regulation 24. The RP shall act as a chairperson of the meeting of the COC. He or she shall ensure that minutes are made in the relation to each meeting of the committee, and such minutes shall disclose the particulars of the participants who attend the meeting in person through video conferencing or other audio-video visual means. The RP shall circulate the minutes of meeting to all the participants by electronic means within 48 hours of the said meeting. Rights and duties of AR of FC. Rights and duties of AR. AR under shall have the right to participate and vote in the meetings of COC on behalf of the financial creditor he represent in accordance with the prior voting instructions of such creditors obtained through physical or electronic means. It shall be the duty of AR to circulate the agenda and minutes of the meeting of the COC to FC he representing. The AR shall not act against the interest of the FC he represents and shall always act in accordance with the prior instruction. Provided that AR represents several FCs, then he shall cast his vote in respect of each financial creditor in accordance with the instruction received from each FC to the extent of his voting. Provided further that if any FC does not give any prior instruction through physical or electronic, the AR shall abstain from the voting. AR shall cast his vote on behalf of all FC he represents in accordance with the decision taken by the vote of more than 50% of the voting share of FC he represents who have cast their vote. For a vote to be cast in respect of application under 12A, the authorized representative shall cast his vote in accordance with the provisions of subsection 3. And application can be withdrawn only with 90% of the approval of COC. AR shall file with the COC any instruction received by way of physical or electronic means from the FC he representing for voting in accordance therewith to ensure the appropriate voting instruction to the FC he represent he is correctly recorded by the IRP or RP as the case may be. Section 27. Replacement of RP by COC. RP may be replaced at any time during the CIRP by the COC by a 66% majority of the voting shares. Section 27 of the code read as follows: where at any time during the CIRP, the committee or creditors is of the opinion that RB appointed under 22 section is required to be replaced, it may replace with him another RP in the manner provided under the section. The COC at a meeting by vote of 66% of voting shares resolved to replace the RP appointed and with another RP subject to a written consent of proposed RP. The COC shall forward the name of IP proposed by them to AA. The AA shall forward the name of proposed RP to the IBBI and for its confirmation, and RP shall be appointed in the same manner as in section 16. Where any disciplinary proceedings are pending against proposed RP, the RP appointed shall continue till the appointment of another RP. Section 29. Preparation of Information Memorandum. Section 29 read with rule. Regulation 36 lays down the preparation of an information memorandum as one of the main function of the RP. An information memorandum is envisaged to be prepared in order for the resolution applicants to provide a solution for resolving the insolvency of a corporate debtor. 29 subsection 2 provides RP shall provide to resolution applicant access to all the relevant information in physical and electronic form, provided such resolution applicant undertakes to comply with the provisions of a law for the timing in force relating to confidentiality and insider trading to protect any IP, intellectual property of corporate debtor it may have access to, and not to share relevant info with third parties. In the box they gave resolution applicant meaning and substituted the section got substituted and resolution applicant meaning. Relevant information means the information required by the resolution applicant to make the resolution plan for the corporate debtor, which shall include the financial position of the corporate debtor, all info related to dispute. So financial position and the information related to disputes by or against the corporate debtor and any other matter pertaining to corporate debtor as may be specified. Regulation 36 of IBBI regulation states the RP shall submit the info memorandum in electronic form to each member of the committee within 95 days from the insolvency commencement date. The info memorandum shall contain the following details. Before they gave something 2 weeks and all, now it got amended to 95 days from the insolvency commencement date. Within latest by 95th day should give. And the information memorandum shall contain what? Assets and liabilities, financial statements, creditors list, guarantees, audited financial statements of corporate debtor for last two financial years, and provisional financial statements for the current financial year made up to date not later than 14 days from the date of application. Particulars of debt due from or due to corporate debtor with respect to related parties. So related party, anything, to or from both. Names and addresses of the members or partner holding at least 1% stake in the corporate debtor along with size of the stake. The number of workers and employees and liabilities of the corporate debtor. Company overview including snapshot of a business performance, key contractor, key investments, highlights and other factors which will bring out the value as a going concern over and above the assets of the corporate debtor, such as brought forward losses in the income tax returns, input tax credit of GST, key employees, key customers, supply chain linkages, utility connections and other pre-existing facilities. Details of the business evaluation, industry overview, key growth drivers in case of a corporate debtor having book value of total assets exceeding 100 crore rupees as per the last available financial statements. Other info as RP deems relevant. Fair value, provided that committee may decide not to disclose the fair value if for reasons to be recorded in writing it considers such non-disclosure to be beneficial for the resolution process. A member of committee may request the RP for further info of the nature described in the regulation, and RP shall provide info to all members with reasonable time if such info has bearing on resolution plan. The creditor shall provide to RP the latest financial statements and other relevant financial information to corporate debtor. RP shall share the info memo after receiving an undertaking from a member of committee to the effect that such member or resolution applicant shall maintain a confidentiality of the info and shall not use such info to cause an undue gain or undue loss to itself or any other person and comply with the requirements under 29 of 2. Next, approval of committee of creditors for certain actions. Section 28 lists out certain action that may be taken by RP only with the prior approval of COC by 66%. Without obtaining the consent, such action shall be void. The RP may also be liable to be replaced. So RP during CIRP shall not take any of the following action without prior approval of COC. List is there. First, raise any interim finance in excess of the amount as may be decided by COC. COC decided one amount, more than that he has raised. Record any change in the ownership interest of the corporate debtor, amend any constitutional documents, make any change in the management of the corporate debtor or its subsidiary, create any security interest over the assets, give instruction to financial institution maintaining accounts of the corporate debtor for a debit transaction. Credit okay, but for debit he is giving instruction from any such accounts in excess of the amount as may be decided by the COC. So both interim finance and debit transaction in excess, if he goes, he has to take prior permission. Delegate its authority to any other person. Transfer rights of financial debts of OC under material contract otherwise than in ordinary course. Make changes in the appointment or terms of contract of statutory auditors or internal auditors of the corporate debtor. Change in the capital structure. Undertake any RPT. Dispose of or permit the disposal of shares of any shareholders of corporate debtor or their nominees or third parties to third parties. Make change in the appointment or terms of contract of such personnel as specified by COC. Section 28(2) mandates that RP shall convene a meeting of the COC and seek the vote to the creditors prior to taking any of the actions. No action under shall be approved by the COC unless approved by a vote 66% of the voting shares. Where any action taken by RP without seeking the approval of COC, such action shall be void. The COC may report the transaction of RP under to the board for take necessary action against the RP. And they gave a case lawyer. COC has given the Supreme stated so that we can ensure the time limit, within time limit to finish.